It's Larry with 7 Sage Law School Prep and another stick figure exam tip. This one is called How to Do, for lack of a better phrase, mini-IRAC, the very fast application of facts to the law. And this fits into a context. There's a previous episode of Stick Figure Exam Tips where we talked about tapering your use of IRAC. IRAC, if done properly, is really thorough, but it can be kind of slow and cumbersome. So at the beginning, you use IRAC very strictly to prove to your professor that you know what you're doing, that you can apply structure to a mess of facts, and that you have a systematic way of approaching it. And then as you get through the exam, you can ease up from that very formal structure, and you can even do it not that far into the exam to give yourself time to capture more issues more quickly. And we also said this about doing mini-IRAC. We didn't really give that much advice. We called it how to taper. You said you don't state the rule in full for a recurring claim, and you ease up on one-to-one fact-to-law matching. Instead, you just kind of list the facts in order the elements. There's a bit more to it than that. In any case, even with short format, you never stop nitpicking the shit out of facts, and you don't cut short mini trials on close or ambiguous facts. The whole he said, she said, he said, she said. So here's a more complete analysis of what we'll call mini-IRAC. First, it's just CA instead of IRAC because it'll look like this. Contrary to what I normally tell you to do, you need to start with a conclusion. Normally, you try to avoid this where you can. You don't have to be super confident about the conclusion. It can be with hedgy language, is likely the better view, But you start with a conclusion because you just don't have the time. The analysis is bare enough that you're going to have to come to a conclusion anyway. You're not going to be able to show as much work on that one, so you might as well start with that, because the conclusion will actually state the law, the claim, or tort, or crime that will be involved. You also skip the identification of the issue, the I part of things, and you don't recite the rule. And I think this is true even if this is not a claim or defense that has been mentioned before. Recall that previously we said you don't have to state a rule in full for a recurring claim. But here I tell you not to cite the rule even if it's the first mention of that claim, because it will be obvious implicitly when you conduct your analysis that you understand what the rule is, but you have to do it in a very specific way. You state the elements of battery. Battery is the intentional and offensive touching of another person without consent. Hurrah. Here's your analysis. You're tying it one-to-one to each element here. Smurfette intended to hit Papa Smurf with Gargamel's shoe. It's kind of a summary analysis, but Papa didn't like being hit with the shoe, so it's an offensive touching. Papa Smurf was Smurfly another person here, and he didn't consent. And then we've got a conclusion here. The better view is that she is liable because none of the issues, the elements was even close. They all point in the same direction to battery. Here's how you might condense that into a CA type analysis, where Smurfette is likely liable for battery, so you just hit them with a conclusion up front. You use the hedge word likely, you don't say is, clearly, and you go to because. 1, she meant to hit him, there's a direct stare at Papa, and there's no sign of intoxication or insanity. So right off the bat, it's clear that you know that the first element involves the intent to actually commit the battery. And so you just address that element directly with the facts. Secondly, the punch was offensive. Sometimes if you can actually slip in the word from the element, it's even better, but you do what you can. Maybe this should have said intended. The punch was offensive to Papa. Third element, this Smurfette's punch consisted of an offensive touching of another person, And 4, nothing here indicates that Papa gave consent. The numbers here are super important because each number implicitly ties the factual analysis to a very particular element. It's a shorthand for this: 1 to 1, 2 to 2, 3 to 3. But if you do this and you use this numbering consistently, the professor will understand what you're doing here when you get to mini-IRAC. So here's the overall template for that. And you can just follow this algorithm in conducting your faster analyses. Now you need to adjust this however you need to adjust it. You can have fights within an element, like within number 1. If the intent is disputed, you have that fight here. And you note that this is a close issue. But you lay out the party, Smurfette, is or is not likely liable for, and you insert the claim, the crime, or tort. And generally, this kind of analysis works best in the criminal law or the tort context. And then 1, 2, 3, for however many elements there are, at least as your professor recognizes that claim, you add the numbers. And this, especially as you get towards the end of a transaction-heavy issue spotting exam. And again, that tends to be criminal law or torts, where just lots of stuff happens and you need to go in and scoop up as many claims as possible. You do this.